So you just got a text message from the other parent that you have time sharing with, your child or your children. And that parent says, hey, we're moving to Mississippi in a month. See ya. And you're like, what's going on? Hi, my name is attorney Anthony Spratley. I'm the owner and founder of Genus Law Group, where we practice family law, divorce, custody, and child support in Albuquerque, New Mexico. So you get this surprising message from the other parent that in 30 days we're moving to Mississippi, and there's nothing you can do about it. And I'm taking the kids with me. And you're like, well, wait a minute, we're on a 50-50 time sharing schedule, and everything about the kids' life is here in the Albuquerque, New Mexico area. Their friends, their school, their activities, their doctor, their dentist, their church, you name it. Everything about the children is here, including, most importantly, the other parent. And you might feel slighted that the other parent is making this unilateral decision without your consent. And can they do that? Absolutely not, especially in a case where there's joint legal custody, and presumably that's what you have if you have some sort of time-sharing arrangement with the other parent. And even in cases where you might not have joint legal custody, which is rare because in the majority of the cases, I would say the super majority of the cases, parents have joint legal custody. But even in the rare cases where a parent has sole legal custody, there's still a notification requirement that they have to tell you that they're moving out of state. Why? Because that gives you the opportunity to object, right? To consent or not consent to the move. And if they insist on moving anyway, then you take it to the court, and then the judge will decide whether or not that move is in the best interest of the child, or children. So if you get a surprise text message at 2 a.m. in the morning, and you read it when you wake up at 6, and it's telling you that the other parent is moving out of state with the child to Mississippi, and there's nothing that you can do about it, you can. If you don't want that to affect your relationship with your children by them moving so far away, because it will, right? It'll affect your time sharing. That's a material and substantial change in circumstances, and it is something that the court will consider as whether or not the children should remain here in New Mexico. So if you get that text message, don't sit on it, act. If you need to, file a motion to prevent the relocation from happening, so that you can ensure that your contact and your time sharing with your children stays intact, so that their best interests are met. Well, that's about it for me, and have a great day.